just getting in a little bit into the estate planning documents here. What are the basic estate planning documents that are going to be included in, all or virtually all estate plans?
Sure. So when I'm explaining this to folks, to potential clients, I usually describe it as being an estate plan is like a three-legged stool. You kind of need these three legs. If you only have two, it's going to tip over. It's not going to be balanced. So right. One leg is needing a will or a trust, or sometimes both together, but that's one side. Then you need a healthcare proxy and living will, so a healthcare decision-making tool. And then you need a general durable power of attorney or a financial power of attorney. And those are your three main components of a well-planned estate.
Right. And that makes sense. And so you touched a little bit on wills and trusts. And I sort of think of these as sort of two sides of the same coin. The primary purpose of both, obviously, is to transfer, provide a mechanism for transferring your assets to your heirs. In some cases, obviously, the trust is unnecessary and you can just simply use a will. But what are sort of the common situations where where people should be considering a trust, or where they might need one?
Sure. Well, I mean, and the main difference, and I should also say, and this happens in our own practice a lot. Sometimes the trust is actually embedded within the will. So it's something called a testamentary trust, because it's not a standalone document. It's part of your last will and testament. So in any situation, the only reason why you're going to create a trust in the estate planning context is because you have some sort of asset that you wish to exercise ongoing control. Not meaning you yourself, because if this is your document, you're gone, you're out of the picture. So this is for the beneficiaries, whoever's going to benefit in the future from that asset for various different reasons. You're going usually with the mindset of protecting that person, protecting maybe the asset for future generations. A trust is going to name, there's two key roles in a trust. You're going to name the trustee. This is the person who on an ongoing basis, either indefinitely into the future or for a specified period of time, is going to have control over that asset. They don't own the asset and maybe they can't benefit from it, but they have the control over it. And then the other key role is the beneficiary, is the person who benefits from the trust. And it can be multiple people sometimes who benefit from the trust. But the most common reason, like I said, is usually protection. I will do trust sometimes even for young families. I know you and I have spoken about how we both have young children. Right. God forbid, something were to happen, to you and your spouse at the same time, and you've got 3 young children. Hopefully you've got a nice insurance policy, some savings in the bank for them, and hopefully you've got some money set aside to take care of them and get them launched in life. Well, if they're 5 years old, they can't manage their own money. So in that situation, you could have a will that includes within it a testamentary trust that's set up for your children that says, okay, everything I own at my death is going to go into this trust for them. Maybe I'm going to make my brother the trustee because he's really close to my kids and knows them. And he's going to have authority over the money until they turn 30 years old, because I know I was pretty responsible by the time I turned 30, and I think my kids will be too. At 30, if there's money left, they can handle it. But up until then, someone else holds the purse strings. That's an easy example of a trust. Yeah.
And so it seems like the fundamental difference is just simply the timing of when they get the assets and the level of control they're going to have. And, you touched on that. And then sort of the other angle I think sometimes people use trust for that I was interested in is, what about the situation where I have I have a child or a grandchild that's already 30 and should be responsible, but maybe either they aren't responsible spending money, or they have an addiction problem, or perhaps they just have a creditor problem. What can you do there with a trust, and how would that work?
So that is an extremely common situation that we have. And again, it doesn't. I often tell people, they come in and I make a joke. I usually tell people that I'm kind of like their priest, like they have to tell me everything. They have to confess everything to me, or else I can't help them, because that's when the stories start coming out about exactly like you said. They've got 3 kids. If someone's got 3 kids, odds are one kid's going to have some issues. It's just the way.
Don't say that.
I know you have 3 children. So it can happen even to 4 or 2 kids. But the bottom line is that it's very common, and people don't need to be ashamed of that. And the same thing I said, you don't want to say, God forbid you have a child who's got an addiction problem. even leaving them $100,000, I shouldn't say even, that's a lot of money, but leaving them $100,000, which is not something that someone could live on for the rest of their life. For someone with an addiction problem, it could literally be a death sentence for them when you come into that amount of money. So in that situation, same thing. There is no age limit. You can put something in trust for someone for the rest of their life. Same concept. So long as they don't have sole control over the money. They're not their own trustee. Maybe they are a co-trustee with a sibling or a family member. Maybe they have no say at all. They have an independent trustee. Maybe they have a bank that's a trustee because it's actually a really substantial amount of money. In that situation, as long as that beneficiary has no control over the money, you can put in something called, for example, a spendthrift provision, which is a provision that basically controls so that none of their creditors, even if they get sued, if they are in a car accident and have a huge lawsuit against them, et cetera, or get into a ton of debt, the money that you set aside for their benefit is protected. And then you, as the grantor of that trust, as the person who set it up, you can make it open-ended to say that the trustee should use it for example, for their health, education, maintenance, and support, which is very common terminology that you see in the trust. Or it can be very specific. You can say it's limited. I want to be really restrictive and say this can only be used to buy a house for them and pay for their housing expenses, or this is meant to pay for their college, and that's it. I generally lean more towards it being more open-ended and flexible, just because you can't really predict, what someone's needs are going to be. But absolutely, it is. You have a lot of tools in your toolkit when you're trying to use trusts.